My name is Linda Kearns. I'm a barrister practising in Auckland, specialised in family law for almost my entire career. And I have had particular interest and I believe expertise in the area of domestic violence. The Domestic Violence Act says that violence in all its forms is unacceptable behaviour. That's the policy of the Act. And then the Act goes on to describe what is violence, and it's physical abuse, sexual abuse, and psychological abuse. Threats to property is violence. And when children see and hear violence, that is violence in itself. So the Act is very specific. There's a lot of case law now about what is psychological abuse. It's intimidation, harassment, multiple texting, that kind of degree of harassment or intrusion on their privacy or anything that makes them feel fearful is violence. It's not just physical abuse. I have a lot of people come to me for preliminary advice. I give them advice and they go away and think about it, or I put them on to counsellors. That's another thing that I do a lot. I see people who are coming in to see me and they are not able or don't feel that they are either emotionally able yet to make the big step of ending it, but they are in an abusive situation, in my view. I have got a range of psychologists and counsellors I refer people to. You have an absolute right not to ever be exposed to domestic violence. So you have a right to obtain what is now called a police safety order. That's an urgent order the police can issue without basically requiring one person to leave the house for 24 hours or whatever the period of time is. For example, if a party is separated and they are getting bombarded with texts, like 20 texts a day, emails, phone calls, then I have often for our clients written letters saying there is to be, if you do not cease this conduct which I regard as psychological abuse, then I will apply for a protection order without notice to you. Now, if someone takes a letter like that to a lawyer who knows what they're doing, they will say, look, you've got to stop, and unless you do, you're going to get a protection order. So that's the first thing that can happen. The second thing is that if you are at serious risk within your own home, then the application can be made without notice, and an order can be obtained to get you safe. You are then relieved of having to have any contact with the other person. They are required to leave. They then have to show to the court that that temporary protection order should not be made final. If the other person takes no steps to defend it, will be made a final protection order. And you are then afforded all the protections under the law. You are afforded the protection for the police to be called out, for the person who has perpetrated violence against you to be arrested, for guns to be taken away, for your children to be safe, and for you to have proper arrangements with children put in place. If you're in an urgent situation, need the police. If you're worried about it, there are organisations, the websites to look at and so on. But if you need legal protection, if you actually need to have the law enforce your rights to be safe, then that's when you need to go and see a lawyer. Lawyers are under very strict obligations of confidentiality. Nobody knows who's come to see me in my office. There are a lot of choices in terms of lawyers. For example, the Citizens Advice Bureaus have got free legal advice. There's community law centres. There's legal aid, which legal aid is specifically designed for protection orders. It's much easier to get legal aid for protection orders than just about anything else in family law. If someone is in urgent need of legal advice, ring your local law society or your family court coordinator. They will find someone for you.